Thomas Höppner, welcome to Digital Markets Research Hub. I'm very happy to say welcome again because it's already the third time where I have opportunity to engage with you either in form of one-to-one interview or a broader panel. And today, I think it's a nice chance to look at the functioning of the DMA and also the functioning of private litigation system within digital competition law and policy, however defined in the EU primarily. And my first question is an invitation to highlight your kind of evaluate. Everybody is doing evaluation for the DMA, including the DMA team itself, of the first 3 years of the DMA, the main achievements and maybe some underachievements of the new regime.
Yes, thank you for the invitation to your podcast. I'm very happy to be here. Now, on your questions, yes, I think we've seen some major achievements, some areas where we may have expected more. I agree with the Commission's report that the ability to transfer data when switching between services is a major achievement. The choice screens for search engines and web browsers are an achievement. Overall, the choices, whether gatekeepers shall combine data or not, are achievements. But I think for me, the most significant milestones are really the specification proceedings. I think they are a major development and very promising, very powerful. So I would put my focus on the specification proceedings as achievement. Regarding underachievement, obviously, all those cases that have not been picked up, non-compliance cases, is regrettable because no one else will now pick them up. But we are having capacity restraints, which may explain that. Regarding the decisions, I find the closing decision in the case of Apple Article 6.3 particularly disappointing. Why? There was a clear infringement also in the view of the Commission, and prior to issuing any formal non-compliance decision, Apple merely promised to change their conduct and to comply in the future. And then a few months later, they implemented those announced changes. And as a result, all the Commission did was close the investigation as if nothing has happened. And as a result, we've seen nothing coming from this proceeding. It creates no legal certainty, no benchmark for monitoring compliance. So I think that was a mistake. But however, obviously the largest or most obvious underperformance happened in the area where we expected major actions from the very start, which is the self-preferencing case that is kind of hovering over all others. As you know, this was one of the major reasons to push for the DMA in the first place. They were very quick, rightly, to pick up Google's self-preferencing in search. They were also within the deadline of 12 months with their preliminary finding in March 2025. But ever since, nothing has happened. And people are wondering why. And I find this regrettable because it overshadows the very strong work that the DMA team does in other areas. And I would really like to see some strong enforcement there.
Can I ask you your opinion about with closing the procedure of alleged non-compliance of Apple with Article 6.3? Can I ask your opinion? My understanding is that you are particularly you feel that it's a shortcoming because it creates a juristic kind of lacuna, lack of certainty, and too much flexibility for the designated undertakings to play this game until the moment when when they are being investigated of non-compliance, and then you can engage meaningfully in the dialogue. We see a very similar, even more probably proactive equilibristic with the mechanism of voluntary commitments, where the commitments precede conduct requirements. Is it, what's your interpretation of this approach? Is it an incarnation of regulatory dialogue where things are much fluid, much more softer, and it's better to achieve them in their kind of not secret, but kind of behind closed doors rather than exposing them too early to third parties, and not necessarily third party, to complainants, business users, and community?
Yes, I think you've revealed a major weakness or mistake, I would even say, of the DMA when it comes to those commitments. Now, you know that under general competition law, if an undertaking under investigation issues a set of promising commitments, the commission will look at it, and if they come to the conclusion, yes, they will solve the issue, they will bring the infringement to an end, they will declare these commitments as binding. Then the company under investigation can appeal those commitments or not. And the commitments have at least an indirectly binding effect on civil courts so that affected parties can go to court and claim compensation. So these commitments decisions have a binding effect. In contrast, the closure decisions, as we've seen in the Article 6.3 case, have no binding effect whatsoever. They just let the gatekeeper off the hook and give the impression there was no infringement in the first place. Even though, of course, the whole proceeding was only launched because it was an infringement, and only at the later stage the gatekeeper came up with a proposed change that would bring its conduct in line with the DMA. But I find it very dangerous to then close that case by simply saying, well, now the problem is gone. Because what is the message then? It is crystal clear. Well, okay, I may as well just wait in every scenario, infringe the DMA in each corner, and wait until they come up with any investigation. If they come up with an investigation and it finds out I'm having trouble defending myself, in the last minute I pull up a solution and say, well, I could stop this infringement now. I promise not to do it any longer. And then the case is closed without any binding decision, no ability for affected parties to claim for compensation, basically with nothing of a deterrent effect and a carte blanche. And I think this was definitely not the purpose of the legislator when they decided there are no formal commitments decision unless in the case of systemic infringements. So I think there's a structural mistake. I believe the only solution to this is to interpret the DMA that it means once the commission has opened an investigation because of an assumed non-compliance, it may only conclude that with either a non-compliance decision, finding an infringement up to the point where company changes its conduct, or that it turns the proposed commitments into a specification decision, thereby making them binding. But simply listening to the gatekeeper, believing them to change, and then closing the investigation, even though there was plain infringement up to that point, is, I think, not what is a possible outcome under the DMA.
I can one go one step further and somehow presume that this formula gives also a kind of a comfort effect of comfort letter somehow against private enforcement, standalone private enforcement.
Yes, indeed. It sends exactly the wrong message. If you close a proceeding, the gatekeeper will wave that around and say, there was nothing to be seen. Nothing wrong here. We were compliant all along. They made a mistake in investigating this in the first place. But this is not what happened. There was a clear infringement, and only because in the course of the proceeding, the gatekeeper said, oh, well, I will stop this infringement now. the commission came to the conclusion, okay, then we may stop investigating. But again, I think this the wrong conclusion to be drawn to then conclude the case with a closure decision. Instead, there must be a binding either non-compliance decision establishing the infringement of the conduct in the past, or a specification decision that turns the promised conduct changes into specified obligations, so that actually the gatekeeper knows what the law now is, and the commission knows also what to judge its future conduct against as a kind of legal benchmark. Otherwise, you just believe in the promises, and it has no legal impact whatsoever.
I also had a question which is somehow similar to the first one about the main achievements and some shortcomings of the DMA. But when the system was designed, there was no textbook example, so it was kind of co-created within the co-legislators, EU co-legislators. And everybody was entitled to have their own understanding of how the DMA should function and what is behind this fairness and contestability ultimate objectives. So if you look at your kind of position, let's say in 2021, and contrast it with the reality of 2026, is it evolving, or does it surprise you much? Is it evolving in the direction which you somehow anticipate neutrally, not expecting but anticipating?
Well, again, it's difficult to throw all cases in the same corner. There were some very powerful enforcement actions by the DMA team for which I applaud them. But then, of course, there were these very obvious shortcomings with the self-referencing case hovering above all of them, where you think, what are you doing? There is a clear-cut infringement. There is a preliminary assessment. Why don't you launch a final non-compliance decision? Why don't you impose a fine? You should actually make several non-compliance decisions out of it, because every single vertical in which Google favors itself is an independent infringement. By now, there should have been several non-compliance decisions. If you don't render those decisions, we will never end up using the stronger enforcement tools for systemic infringements. That is exactly what the DMA had foreseen, that there will be gatekeepers that simply ignore the law and will hope that they can negotiate their way out with some dodgy proposals. And that should not have happened. And I don't understand the logic behind the current hesitation. In my view, it is apparent that if you impose a non-compliance decision with then automatic penalty for continued non-compliance, your leverage is much higher than to just say, well, look, you please give me a proper solution and then I may spare you from a fine. This is not how the reality works. Google has made so many promises by now and they were all empty. So that is kind of the disappointing story so far of the DMA. But again, I would not draw the conclusion from that the DMA is having no teeth. As I said, the specification proceedings are promising, and the DMA team is doing an incredible work.
If you look at the DMA as a web of communication between the DMA team and designated undertakings with core platform services, such long catalog of obligations, I imagine the communication is very kind of nuanced. It's not about no, yes or no, compliant, non-compliant. There must be probably a kind of a network of mid positions, some compromises and solutions. If we interpret the provision A less strictly, you will comply meaningfully with provision B. Does your legal benchmark, your normative kind of position as a professional expert in this, as an expert in this field, does it allow for such kind of fluid, less transparent, less tangible means of communication the very fact of such communication it compromises the foundations of the DMA?
I think it opens a very dangerous path. We all know about the risk of a regulatory capture, where the regulator primarily talks with the company that it is supposed to regulate, and that this sometimes creates, well, tensions and certain conflicts because they may not listen to external positions. And what adds in this moment here, not in favor of effectiveness, is complainants have no legal status. So the Commission knows that if in this dialogue they land towards the gatekeeper and listen to their proposals, accept their proposals, and are more lenient on their end, they don't have to fear any consequences because the gatekeeper will not litigate against them, will not appeal the decision, and the complainants have no right to do so. This, of course, creates an incentive which is very unfortunate because it means in case of doubt, I rather lean towards the gatekeeper, which is in case of doubt, non-compliance. That is not what the legislation envisaged. And I find it regrettable that the case of self-preferencing suggests that we are in the midst of that. It's such a clear-cut infringement case. There's no reason to hesitate, negotiate, find amicable solutions. That's not the job in this scenario. The job is to make clear this is what the law requires. And if it's through a specification decision, but the Commission needs to be clear what is expected, and then it should be up to the gatekeeper to either follow suit or bear the consequences, and they must mean mounting fines. And at the moment, I think we've kind of lost sight of that for whatever geopolitical reasons that should not play a role in that setting.
But during the DMA discussions, there was a powerful, in my view, counter-argument to this approach is that if you grant procedural status, and in one of the iterations of the DMA in the Parliament, in the European Parliament, it has been changed, granting third parties with legitimate interest some procedural status and competencies. Would it create a situation where out of nowhere some Astroturf organizations would emerge and will spam the enforcer with which would somehow paralyze the effectiveness of the function of the mechanism itself?
I think there are very strong tools to prevent that. We are still having a lot of discretion with the authority. If there are frivolous complaints where you see straight away, look, what do you want here? They will just not be picked up. But once an investigation has been launched because the Commission got convinced, yes, there is something in there, I really see this, there is no reason why to exclude the complainants. They are providing very valuable inputs, and they are the ones that the Commission will have to listen to if they want to get external insights. And the more they get involved, less compelling it is to then say, well, but if the decision is finally against you and the Commission interprets the law in a manner that you disagree with, you have no right to challenge them for it. I think this is a false outcome. Once an investigation has been launched and a complainant is involved because they've brought it to the attention of the Commission, I think they should have the same right when it comes to challenging that decision, also to create a certain counter incentive for the Commission to not just lean into one direction to prevent an appeal.
Next aspect of the same problem of resource capacity and limitation is the possibility of national competition authorities to assist or somehow contribute to the functioning of the mechanism where the Commission is the sole enforcer of the DMA. We already see some examples. Maybe can you reflect upon some good and maybe not particularly effective mechanisms where national competition authorities help the DMA team?
Yeah, I think we need to look at this from a broader perspective. The centralization of enforcement powers with the European Commission has its ups and its downs. And one of the downsides is that it basically turns into a situation where everyone then relies on the Commission to do their job. But there is so much to do. There's so many infringements going on that basically they are too small a team to handle all these issues. And the only beneficiary of that are the gatekeepers. And it makes no sense to keep those national authorities out that really do understand these markets too. It's not as if only the European Commission knows what they are talking about. There are strong national competition authorities that have fought and won very complex digital cases, and it makes no sense to leave them out of this debate. Instead, it creates an incentive for them to then turn their focus to other national cases that may not merit that much attention, just for them to stay in the game of enforcement in the digital area. And then we see some odd cases popping up and you think, look, this should never have had priority. Compare this small case to the major case that's happening with relation to a gatekeeper, and the only reason you are not pursuing it is because you are not allowed to do it. So cases are left behind because the Commission can't pick them up for lack of resources, and other cases are instead pursued at national level that don't merit that attention. That is a misdevelopment, and therefore the idea of allowing national competition authorities to assist the Commission makes complete sense. Look at the cases of really urgent help, where we really need interim measures. It's crystal clear that we would have a much more powerful enforcement system where those local players that are affected, for instance, if it's a measure that only takes place in a certain member state or only affects a certain company that may have been thrown out of the App Store or is invisible in search or whatever, that they may first turn to the national competition authority to verify their complaint, so that the national authority looks at the facts. Is it correct what they are stating? Is it true what they are claiming? Is this really a legitimate claim, or just what you mentioned earlier on, a frivolous litigation that tries to get some attention? And then the national competition authority can already pick the good from the bad and make a sophisticated recommendation to the Commission. Look, we've looked at the facts. It's correct what they are claiming. It's correct what they state. They are really harmed. This is really what happened. I believe it's worthwhile to look at it, Commission. I don't see any harm with that. So I applaud this development from the Italian authority. They are fully aware about the limits of the DMA regarding the enforcement. They are aware that it's about the fact-finding element, which, however, takes a lot of work, and where the Commission may have some, prioritization issues. The highest hurdle for a complainant is whether the authority looks at the case at all. And if this is a means to lower that hurdle by convincing a national competition authority, look, there is really a strong and important case, and this is really urgent. We need action now. I see that this is a great idea. It also builds a bridge between, affected parties in some member states that feel closer to their national authorities. They speak their own language. They know how the procedure. They know the people working there. They know how the system works and feel detached from the European Commission. So why not allow them to raise their concerns with their authority, in front of their door, explain them the case, explain their concerns, and if the authority, which is smart enough to distinguish between real cases and frivolous cases, if they are convinced, yes, there is a case, let them forward it to the Commission, get them involved, so that overall we have more capacity working on these cases and really increase the pressure towards compliance.
And a typical counter-argument against referring to fragmentation is kind of a little bit synthetic, yeah, you would say?
Well, fragmentation, what is the alternative? The alternative left is if you are an affected party in a member state that knows this conduct only affects me, the chances that the Commission gives this case a priority is close to zero. I could spend now a year begging, please look at it, wasted money. So what they will do instead, the only option left is turn to private enforcement, so go to court. And now the court will look at it and will have to look at it. The risk of a fragmented landscape is much higher there, because obviously a competition authority will have by nature more experience with that, will know more about digital markets, will be closer coordinated with the European Commission, can intervene much earlier rather than going through the route of civil enforcement where judges may be in charge for which it is the first competition case ever. So I think this fragmentation argument is fully overblown. And in a case like this, where a national competition authority does the groundwork, it's even less compelling. So I think this shouldn't play a role here.
You mentioned among the main advantage, the main things which they may delivered already is the use of the mechanism of specification procedure, where obligations are interpretable widely and they're interpreted by native speakers against people who are embedded in regulatory vocabulary and expertise. And thus the standard of discussion is very complex. Specification appears to be a solid road for narrowing down at least the room for misinterpretation, etc. We already have four, two have been closed already, and two are ongoing. Two which have been closed, they're recent, 2025, closed with decision. I mean, first of all, I wanted to ask you about the first two. I don't know if you've been dealing with them directly, but definitely you know the atmosphere. What do people think? How effective this mechanism proved to be in the first kind of cases where you don't expect with the first procedure to target like at the very center of your aim? And yet, are we learning in the current open investigation specification procedures from the previous ones?
Yes, I believe specification decisions are a real game changer, in particular in the current geopolitical framework where the Commission seems afraid to release any non-compliance decision, even with ridiculously small fines. And in that setting, where at least they should ensure full compliance, a specification decision has the advantage it spells out in detail what is supposed to do and what compliance shall look like, so that everyone outside of the Commission as well can see black on white, okay, these are now the legal requirements specified by the European Commission. This is what we can expect. These are our remedies. This is what we can now insist the gatekeeper to do. So it strengthens the position of all those harmed parties. Of course, it's kind of regrettable that from a procedural reason that I can't quite grasp, the time period is limited to 6 months, which is really not appropriate for something as important and powerful as a specification decision. I think there was some misjudgment there, but also I think because they never anticipated that these proceedings would become so important in the geopolitical framework. But leaving this aside, I think the learnings from these specification decisions were, yes, the Commission is capable through a good equipped team of technicians, data experts, economists, and lawyers to really compile powerful decisions that leave only limited room for circumvention. And in my view, this brings the advantages of the UK system under the DMCC into the DMA. The main advantage of the DMCC is really this regulatory discretion where the biggest expert in the room, the regulator that really knows the technology and the ins and outs and of everything, can impose fine-tuned remedies that are so fine-tuned that they can really make a difference. And the DMA was under the suspicion, well, these are still kind of general clauses. They promise to be self-enforcing, but in reality, they are not, because you can interpret them in 10 different ways if you have 3 lawyers. Now, specification decisions have the advantage of really bringing more clarity into that. And gatekeepers have asked for more legal certainty and clarity for a long time. So in a way, they should applaud this too, because ultimately they've got this clarity now. Of course, there is a risk that these specification decisions lean towards the wrong end of the scope, because of regulatory capture, where they then believe the technologist of the gatekeeper rather than the external technologist what is possible and what is not. But if that is precluded or the risk limited by involving third parties and experts in the field that really let the Commission know how this works and how it doesn't, then I think specification proceedings are a great tool, and I applaud the Commission for going through this very hard work of making them work.
And looking ahead, or well, for Apple specification procedure, not even ahead, at the current situation, what is the legal status of these implementing acts? Would they be binding for the Commission, for the DMA? Can the gatekeeper then refer to any provision in the specification decision saying, look, that's what you ask us to do. You had the opportunity to further specify. You didn't use this opportunity. You still leave some room for interpretation, and we obviously interpret it differently. Can they be amended? And what is it like? Should the DMA team be very careful with how they phrase the decision, the vocabulary of the decision itself?
Of course, they should be careful, but they are careful to preclude any circumvention and all the rest of it. But it is a major starting point. And within a very short period of time, if later on the Commission realizes, well, we may have left some loopholes there and we didn't cover all aspects that do matter, and here the gatekeeper tries to circumvent it, I think the natural consequence would be to add a new specification decision and fix the wrongs that have been identified. But the risk of getting something wrong or being too short at some elements should not scare them off to do this important work to start off with. You can fix it later. Importantly, I think the enforceability of this specification decision is an important element of this. It creates legal certainty also for the affected parties. And in my reading, they are having a binding effect. So therefore, they are a tool that really benefits all parties one way or another.
Mm-hmm. But ultimately, in the court, you think the provision of obligation itself would have superior power vis-a-vis the specification decision, or it will be perceived through the prism of specification decision?
Well, we need to distinguish between which court. If the specification decision is appealed, obviously then the interpretation of the DMA itself by the general court and then the higher court will be decisive. They will not assume that the specification is necessarily exactly how the court interprets the DMA provision. However, it's a different situation when you talk about civil courts. Civil courts may not deviate from Commission decisions, and the specification decision is a Commission decision. So the civil court may not say, look, we believe the DMA should be interpreted differently, and what you are imposing on the gatekeeper here is not in line with the underlying DMA provision. So while the European court will judge this specification decision against the wording of the DMA, the civil courts will not have this freedom because they may not put their view over that of the Commission.
Makes sense. In this conjunction, another question about interpretation. We have some in the provisions of the DMA, in some provisions of the DMA itself, but also because of the very nature of European law, we have equally binding requirements, or you can make a meaningful argument about equally binding requirements which move the compliance in different directions, particularly making it easy to do if you are motivated to once over sudden start being very vigilant with your obligations vis-a-vis other European laws. And in my observer kind of perspective, the apotheosis of this is the provision of Article 8.1, which on one hand presupposes and claims for effective compliance, and on the other hand, so effective compliance, and that requiring the gatekeepers to assure the effective compliance. And in the same subparagraph, it talks about the duty to comply also simultaneously with other laws, such as, so the list is not exhaustive. And this duty is bound with very important laws which have been adopted earlier, which probably it's a kind of race to the bottom, which give the opportunity for gatekeepers to play the race to the bottom argument and circumvent, but not circumvent in the spirit of Article 13, but circumvent in saying, look, we are complying with the DMA itself. Is it a problem? If it's a problem, is it avoidable problem or just part of legal profession?
I think it's an avoidable issue. Firstly, it's easy to kind of misinterpret what Article 8.1 sentence 2 actually says. If you read it and take it seriously, all it says is if a gatekeeper decides to implement certain measures to comply with the DMA, these measures must also comply with other European laws. In my view, this is kind of a no-brainer. Obviously, you cannot create measurement to implement the DMA, which is outside the acceptable legal framework. But what is equally important is to understand this actually imposes additional obligations on the gatekeeper. It is not meant to provide a shield from implementing the DMA by referring to an alleged infringement by doing so, complying with the DMA, with other legislation that are applicable to non-gatekeepers. I think it is inherent in asymmetric regulations such as the DMA that those that are subject to it are subject to stricter obligations than non-gatekeepers. And this may mean that we can expect more from them to comply, not just with the obligations under the DMA, but with the laws that they need to then also comply with to fulfill their obligations under the DMA. And how can this be fixed? I think we should understand that these other legislations, horizontal legislations that apply even to the smallest companies, impose minimum standards, legal standards, but that does not mean that we cannot expect more from gatekeepers, which are much more powerful. And secondly, of course, it creates a certain need to align the law to find common ground so that there are no misinterpretations of the same legal requirements. To give you an example, in the pending Article 611 investigation on search data sharing, Google defends itself by saying, well, but if I share the data the way you want me to share the data, I will infringe the GDPR. So I cannot do that. I will only be able to provide much, much less data in a GDPR compliant manner. However, a closer look at it quickly revealed that what the DMA team expected from Google in the preliminary findings is no less than what it is required under GDPR anyway, and that the interpretation of, in particular here, anonymization of personal data is fully consistent under Article 611 as it is under the GDPR. What helped here were guidelines then by the European data protection authorities with a view to how the GDPR should be interpreted also within the DMA. And this, of course, creates legal consistency and helps the Commission to do their job and make sure the gatekeepers are not hiding behind some alleged infringements of other laws.
To have cyber resilience and others. So I imagine what they have to do is just to scrutinize the entire corpus of EU legislation. And do you think they already have the list of other excuses once the GDPR one is exhausted?
Well, we've seen Apple raising security issues at each front, Google too, that basically implementing these obligations would open the door to spams and all sorts of bad behaviors by third parties. But again, if you look more closely, what they are actually threatening with is if we implement that, we may as well implement it in a way that allows others to take advantage of it. And we could then create problems by basically putting a blind eye to certain elements. And then, well, you will see the problems coming by us doing a bad job. And then we will blame the DMA for it and ultimately the commission for it by not doing our own homework properly. So I think it's quite a shameful conduct to do. So I hope the commission is rigid on this and is reminding them, look, there's a DMA you need to comply with, but obviously the other obligations are also there to comply with. So don't, not comply with the other obligations only to then argue, well, look, the downsides here are a direct result of us complying with the DMA, which in fact it wasn't.
You talk to very, very competent clients who understand the nitty-gritty, the DNA of the business models which are at stake. And we understand that for search engines, access to such data is critical. But how important, from your perspective, this sharing of this data is for Google? Would they really endanger the de facto monopolistic status, particularly when we talk about inclusion in the preliminary finding or emphasis for a large language model or like AI operate chatbots? Or it is just a matter of principle that look, what is yours is mine, and we don't want to share our kind of data with others who will be free rider on us. Which motivates more?
I think it's not a matter of principle in this particular case. We've analyzed what are the crucial barriers to entry in the online search engine market. It quickly materializes that it's really the data that feeds the algorithms. You can have the best algorithms in the world if they don't have the data to feed on what is currently searched around the globe, what is then looked at, what is clicked at. If someone searches for football Mexico today, the interest is completely different than it was, let's say, half a year ago. And that, realization, what a query actually implies, which interest it implies, that can only come from the amount of queries you assess. So scale is really an essential input here to feed your algorithms, to make them learn what is currently looked after and what do users want to see if they search for football Mexico. And this real-time data would really enable our search engines to increase the quality of their search results pages. Obviously, they still need proper algorithms, they still need their index and everything around it, but they could use that much more powerfully by having that search data from Google. So that is a genuine fear of Google and not just pretended.
All right. And what do you think about other requirements which are like which are part of this license program, or where until the specification decision is issued and enters into force, such as like you're not allowed to operate this kind of optimization business, or you should be from certain jurisdictions. If you look, for example, at such access seekers, I imagine as Microsoft, they operate such optimization stuff. So would they be also ineligible based on different criteria?
I think the eligibility criteria are important, and I see that the Commission should pay attention to it in both directions. It could be too broad and it could be too narrow. Obviously, the eligibility needs to be broad enough to really allow challenger search engines that can show a genuine interest in entering the market, invest in it, and steadily grow in it to get access to the data. But at the same time, the eligibility criteria should preclude players that never really mean to enter the market and are only there to kind of get access to promising data to draw whatever conclusions from them without really benefiting the market developments. So I think safety precautions are indeed called for, but the safety conditions should be more towards making sure that they don't do anything dodgy with the data and they may get access to. And therefore, I agree with verification requirements that, you should really look at what these companies do with that. Do they have proper technology in place to make sure the data doesn't leak? Are they sophisticated enough to deal with the type of data? And will they generally use it for the good? But then, of course, you also need to make sure that these eligibility criteria are not overreaching. And when you talk about optimization services, obviously, one argument of Google is we wouldn't want to have a system that allows others to play our algorithms to then basically re-engineer the criteria that we have for rankings and then design their own websites to fine tune these requirements and gain an advantage that is not legitimate. So this gaming of Google's own algorithms by kind of re-engineering results pages is a legitimate concern. But I think this can be precluded, and a mechanism that really looks at what are you using the data for, and are you really in the business here of online search is the right way to preclude these risks.
And should the final word be for the independent auditors or for the Google team itself?
There's always a risk that if you delegate any decisions to the gatekeeper, they will pursue a decision that is most favorable to them and least favorable to competition. So obviously the decision cannot be with Google, if anything with the auditor, ideally then monitored by the commission so that the commission can identify whether a certain yes or no decision is driven by anti-competitive motives or by genuine concerns about safety.
I also wanted to ask you, Thomas, about the development in private I mean, it's such a broad topic, but I wanted maybe to ask you a question about the evolution of the system. Do you see, or at what stage we are now? Do you think we will continue growing so rapidly in private enforcement friendly jurisdictions? At least will other jurisdictions maybe join the club? Or the market is more or less at the plateau and it's about maturing and refining the nitty-gritty of things, or the growth is still exponential and we can expect new big players emerging or requalifying themselves in this industry?
It's a good question regarding the development of private enforcement. There are some jurisdictions that are in the pole position for several reasons, procedurally, substantially, what kind of claims you can bring, what the procedure allows you to claim, and all these things. And not much movement is happening there. Overall, I think it's fair to say that private enforcement really kept its promises. We've seen some great decisions that sometimes also revealed shortcomings in public enforcement and thereby prove that there is a case for private enforcement. And I think it also showed that this case is not just in damages, for past infringements, but also when it comes to injunctions, something that is sometimes overseen. I think that civil courts can play a larger role when it comes to really granting interim relief, where authorities will not pick up the case in short of capacity or because it's too small a case from their perspective. So I believe that private enforcement will continue to grow and become more sophisticated, and that is not a bad thing.
And just mechanistically speaking, we know kind of top tier law firms which are kind of almost household names in the profession. Is there a market also for the kind of for the second division of firms which are kind of boutique, maybe startups by young graduates? Or you need to have your own kind of scale of expertise and connections and understanding of things in order even to start playing a small case?
Well, some underestimate the complexity of private enforcement. This is really a specific field of law where you can make a lot of mistakes on the procedural side, on the substance side, jurisdiction, serving of claims, who is actually the right venue to go to. So it requires a lot of expertise to get it right. And we've seen cases where plaintiffs were represented by firms that haven't done that before, and then they produced really bad cases. They either lost or even where they won, the outcome was not as good as it could and should have been, sometimes creating very bad case law and then being more a win for the other side. That is regrettable. So I believe that there are reasons for this focus on few specialized firms because there's typically also a lot at stake. And if you then mess it up, it's quite dramatic.
And maybe one of the last questions is, which expertise are you looking at when you look at those who wanted to join your law firm, or maybe you talk to your peers? Is this kind of traditional legal good solid expertise, or in addition to it, you need some other features which are rather new and perhaps maybe current students may learn from this message and focus practicing this muscle as well?
Well, I've seen obviously quite a few associates in my career, and what always surprises me that ultimately the basics, a good academic qualification with sophisticated skills in all elements across the board, writing skills, oral skills, analytical skills, really what you learn at university is still key. I don't expect an associate to know the nitty-gritty of AI when they start, but I do expect that they know the nitty-gritty of civil procedure. And that if I then explain to them, look, you need to familiarize now yourself with this sector, they are willing, prepared, and motivated to do that. But that is typically not really the issue. The quality differences come when really to the basics. Write a proper statement that is compelling after a proper research that is not just scratching at the surface, but really makes a deep dive. And from my experience, the better the academic qualifications, the higher the chances that they will also do well in practice.
2026, second half, where will be your attention focused at? And maybe we should just also keep an eye on the developments.
First decision I'm looking forward to is this Friday, the ruling in the price runner judgment in Sweden, a huge damages claim for several billions. Another element is, of course, the 2nd of July, we see the Android judgment of the Court of Justice with all its implications for the discussion on the Article 102 guidelines. So in addition, we see the DMA specification decisions where the deadline is on the 27th of July. I think they will also be relevant. And I'm looking forward to what the Commission does with the open proceedings, site reputation abuse, self-preferencing, 5.4 for Alphabet. And I hope that we will see, these cases coming to an effective close so that the DMA remains a success story and not a paper tiger.
And the last question, Thomas, is an invitation to provide recommendations to students, and maybe particularly looking at this kind of flood of information. And you mentioned few developments which will happen already in July, and so much is going on, and it looks that the speed with which these major developments emerge is also accelerating. How not to lose the control, how to keep, the intellectual, mental sanity, and yet maturing, mastering their professional skills.
That's a very good question. Now, I think it distinguishes or it differs between undergraduates and postgraduates. Undergraduates should not get nervous about anything that happens around their studies. They should fully focus on their studies, try to be amongst the best in their year, and then they will get a job no matter what happens. Even if they've looked at AI or not AI, doesn't matter. Don't let these extra programs about everything that happens in the world distract you from where you should put your focus on is getting great grades. Now, postgraduate is a different matter. Obviously, they have the flexibility to choose where to look at and deepen their knowledge. And there I would say, obviously, go with where the markets are going. Look at the future growth markets, look at AI, look at robotics, familiarize yourself with these industries, do something in this area rather than focusing on some areas that may be legally challenging, but will not secure you a job because if an employer looks at your CV, they will just say boring and rather purchase someone that, in addition to very good qualifications on the basic level, brings an extra expertise in future growth markets.
Thomas Höppner, thank you very much for sharing your ideas with us.
Thank you for the invitation. It was a pleasure.